Good morning, Ms. Pumphrey.
Good morning. May it please the Court. I'm Janet Pumphrey for Barrero-Cruz. Before I begin, first I hope I don't lose my voice. Before I begin, Mr. Cruz had asked that I continue this argument, and I spoke with the clerk's office. He wants to file a pro se brief, and the clerk's office assured me that you would accept his pro se filing, and I was going to tell him 3 weeks from now would be the end of. Would that be reasonable?
Well, why don't you file a motion?
A motion asking for 3 weeks before you decide.
Just file a motion that he be permitted to file it, and we'll take care of the time.
Okay, thank you so much.
Thank you.
And that's actually a good segue into the first argument, which is the motions for the continuances. There's obviously great latitude for a judge to grant or deny a continuance. But here, the request for a continuance began on the first day of trial, and they continued throughout the trial. On the first day of trial, Cruz moved to represent himself. He said his counsel only had 90 days to prepare his case, and there had been 2 previous motions to continue, both of which were denied. The court denied the motion on the grounds that the case was 2 years old. The crime had happened 2 years before, and Cruz was not really asserting anything specific or additional that trial counsel needed specifically to do to prepare for trial. On the 4th day of trial, Cruz again wanted to address the court himself about the confusion between himself and his attorney. Again, he argued that his attorney was not prepared to defend him and that his attorney had no coherent defense strategy. Defense counsel moved for a mistrial. He told the court that Cruz had just provided him with information and witnesses that would completely change the focus of the defense. Cruz wanted to change the defense from one of misidentification to one of self-defense. Defense counsel told the court that this was going to require additional witnesses, and the court denied the motion. Defense counsel again moved for mistrial, pointing out that Cruz had, at this point, taken off his earphones, where the translation was coming through. He was refusing to talk to him, and that he was giving counsel instructions that were inconsistent with the defense at all. Counsel told the court that he really could not defend the defendant under these circumstances. He had filed 3 unsuccessful motions for continuances already. He said that Cruz did not understand the process and that this was just plainly unfair. Later on the 4th day, the trial counsel again told the court that Cruz was refusing to communicate with him, and Cruz corroborated that the counsel was not doing what he wanted. These events show that counsel was just not able to effectively represent his client. He was unable because of lack of time to prepare, because Cruz was refusing to communicate with him, and because Cruz was forcing him.
May I ask, the attorney was appointed to represent him at what point in time?
It was about 3 or 4 months before the trial.
Say 4 months before the trial?
Right. By not allowing the request for the continuance, the trial court essentially forced Cruz to proceed with a lawyer with whom he had no relationship. And for those reasons, it was abuse of discretion to deny the motions for the continuances or the motions for mistrials. The prior bad acts evidence.
Ms. Pumphrey, could I just ask you this? And I recall reading it. How many counsel had Cruz had?
2.
2.
The prior bad acts evidence. A significant percentage of this trial was prior bad acts evidence. That by itself put undue influence on collateral matters and not on the facts of the case. Before trial, Cruz moved to exclude this evidence, the evidence of acts of aggression towards Iris Sanchez, who is his former girlfriend and also the victim's stepdaughter.
Wasn't it relevant?
Well, I would suggest that it was more prejudicial than probative.
So then the judge makes
that balance.
And so what we're asked to do is review the judge's decision to see whether or not that was an abuse of discretion.
Right.
So you say it was relevant, but it was more prejudicial than that.
I would say it's marginally relevant also because it really was acts of aggression against Iris and not against Iris' stepfather.
But didn't the stepfather have some interaction with the defendant because of this?
He did.
And didn't he tell him to back, I'm going to paraphrase, to back off?
Right. And leave her alone.
Yeah, leave her alone.
Right. Well, Judge Botsford did exclude some of the acts, but she let in 2. The first were the events around the obtaining of the restraining order, and second, the events around the violation of the restraining order. Iris worked as a receptionist at a paper company in Jamaica Plains. She testified that in September, and their relationship was about 2 years old at this point. She testified that in September 2003, she delivered the pamphlets. Their relationship was starting to deteriorate. She was at work when Cruz showed up. He was waiting in the parking lot for her. He grabbed her, pulled her from the van, and her co-worker had to step in between them to sort of break this up. At this point, she terminated the relationship with him. And then just a couple of weeks later, he called her to get her back. She took his call as a perceived threat, and that's when she got the restraining order. The second incident that came in was the violation of the restraining order.
Excuse me, could I ask you a fact that I don't know if it was made clear from the briefs? Is there anything in the record as to whether or when the defendant put his earphones back on? He took them off at one point.
He took them off during the fourth day, and I
Right.
believe he put them back on.
You mean very soon thereafter?
Yeah, because the trial continued to I want to say day 6. I believe he had them on, but I'll double check.
I'm just wondering if it's in the record, because there's
I'm not
something
even
in the
sure it's
record that indicates he took
This
them
may be
off.
all that's in the record, because that's all I remember was the fourth day when he took them off. And I think he took them off twice, but whether he put them back on, I'm not sure.
Thank you.
The second incident, she's working at the paper company. He's under the restraining order. The location of the paper company is covered by the restraining order, and Mr. Cruz shows up with flowers for her. He desperately wants to get back together with her, and like all prior bad acts evidence, this evidence of the restraining order and the violation of the restraining order was more prejudicial than probative in this case. It proved really only to the jury that the defendant had a criminal propensity, and that he was of a bad character, and that's exactly what should not be admitted in a criminal case. Most of the testimony was collateral matters and didn't go to the heart of the crime itself, and it should have been excluded. Third, Mr. Cruz's right to counsel. As I said in my first argument, the counsel was not given time to prepare. He couldn't communicate with Cruz. Cruz gave him information in the middle of trial that would have completely changed the theory of defense. And I would suggest that the attorney-client relationship had deteriorated so much at this point by the middle of trial that he was really denied effective assistance of counsel. And finally, under 33E, this court obviously can consider matters, not only the issues that are clearly preserved for appellate review, but also legal and factual issues that are apparent from the record. Mr. Cruz's conviction must be consonant with justice. And this is a case of a man who was distraught over a woman. She broke up with him. She got a restraining order. He was not allowed to see her. He brings her flowers at work. He was desperate to get back together again. And then he lost it. He believed that the parents were keeping them apart. This case was tried as a misidentification case, and the jury obviously didn't buy that theory. I would like for you to suggest to you that please consider Mr. Cruz's state of mind as an impassioned and jilted lover. And I would suggest that a conviction of second degree would be more consonant with justice than under the facts and circumstances of this case. If there are no further questions.
Thank you, Ms. Pumphrey.
Thank you.
Good morning, Ms. Noble.
Good morning, Your Honors. May it please the Court, Janice Noble on behalf of the Commonwealth. With me is Mark Halal, the trial prosecutor in this case. I'd like to begin just by briefly addressing Justice Cowan's question about when the defendant put his earphones back on. That is actually in the record at Volume 4, page 17. The record indicates that he complies when the trial judge asks him to put his earphones back on to have a discussion. There's no further indication that he took them off. Thank you, Your Honors. I'd like to begin by addressing the first argument, the motion to continue. On the day of trial, the defendant filed a pro se motion to remove counsel. There was not, at least by my reading of the record, a live issue of another motion to continue before Judge Botsford at that time. All trial counsel said was, I concur that there hasn't been enough time to prepare.
Well, trial counsel had filed 2 previous motions to continue. Am I right, or just one?
2 previous motions, Your Honor. The first one was filed on April 24th of 2006. At that time, the parties, by agreement, selected June 9th as a trial date. Prior to that, the trial date had been June 5th. So there was an extension of a few days after that. On May 31st, another motion to continue was filed. That's reproduced in the Commonwealth's appendix. The motion to continue indicates that trial counsel has read through the file, that he is familiar on some level with the case, that he reviewed documents, visited the defendant in jail, as had his investigator. At that time, there was a phone conference held. It wasn't a formal hearing in a court. It was a phone conference. Judge Botsford denied the motion to continue at that time. The trial remained at June 9th.
What was, I saw this and I just can't remember, what was the reason for trial counsel? I mean, other than I'm not ready for trial, what was the reason he gave?
He gave a couple of reasons. He claimed a heavy workload, which I think many attorneys would concur and say that we all have that, and that the defendant had given him some information, and this is a quote from his affidavit, assuming it's true, could change the defense strategy.
Didn't that happen at trial?
It happened at trial again, actually.
It also happened in or around May 31st.
Yes, that's correct. According to counsel's affidavit, unfortunately, we don't have a transcript of that phone conversation, so we don't know how it was discussed. The issue of a continuance was raised again on day 4 of trial. Actually, let me back up for just a second. Justice Botsford denied the motion to withdraw. I don't want to say convinced, but certainly had a discussion with the defendant as to whether representation was the better course of action as opposed to proceeding pro se, and the defendant acquiesced in that and said, yes, he would agree to Attorney Curtis's representation. The issue was not raised again, and there was no formal motion to continue. On day 4, the defendant again asked to address the court and continued saying that there was that counsel wasn't asking questions that he wanted, that the defense wasn't going as he would have liked. Turns out that it wasn't really a differing defense strategy if we look at the transcript. Really, it was more of the defendant wanted counsel to ask certain questions. Counsel didn't feel like those questions were actually in his client's best interest. How this was sort of mediated by Justice Botsford was that she said if the defendant wanted a question asked and counsel didn't agree, they would approach sidebar and have a discussion about it and eventually ask the question, or if he could not in good conscience do it, not, but it would be put on the record. That did not happen once after that particular discussion occurred. So, nor did the issue come up again of additional witnesses being called, which was this change in defense strategy from misidentification to self-defense. No witnesses were brought to the court's attention, and the court really expressed a willingness to work with counsel and work with the defendant if additional witnesses or theories were brought to her attention. This wasn't just a witness identification case. Counsel also presented evidence or cross-examined effectively that the identification was unreliable, that the ballistics evidence was unreliable, that the investigation was shoddy, that certain testing hadn't been done. All of this was brought before the court. There is nothing in this record to show that Attorney Curtis was either unprepared or that the defendant somehow did not get a fair trial. And in any event, a defense of self-defense likely would have been entirely inconsistent with the evidence presented by the medical examiner that the victim was shot at very close range, inches away from the back. It's somewhat of an inconsistent with the defense of self-defense. If the court has no further questions on that particular issue, I will just very briefly address the prior bad act evidence. The prior bad act evidence was inextricably intertwined with the murder of Leonardo Perez. The relationship with Ira Sanchez showed the context. It was motive and it was state of mind, and it was very clear.
I'm sorry, I just missed your opening sentence.
I'm sorry, Your Honor.
No, it's my problem.
The prior bad act evidence was inextricably intertwined with the entire picture that was being presented to the jury. I'm sorry if I didn't entirely say what I said before.
No, I was writing a sentence here.
This was motive and it was state of mind. From the beginning of the case, defense counsel opened with saying that there was no bad blood between these two men. There's really no reason, there's no plan. He closed with the same type of a theme. Motive and state of mind was critical. But even if this court finds that this shouldn't have been admitted, taking the overwhelming evidence, it really didn't matter. He was seen by eyewitnesses who knew him and had known him for years with a gun against the victim's back. He was seen by a neighbor who knew him running out of the house, or walking out of the house more appropriately, with a gun in his hand. He was found days later with the murder weapon in his possession and with gunshot residue on his clothing. It's an extraordinarily overwhelming case, so even take that out, it doesn't really matter. But I do suggest to the court that this was properly admitted, that this was context, that this was an important part of the Commonwealth's picture to the jury. And Judge Bosford did engage in a strong balancing test. She limited some very damning evidence of how the defendant had put a pillow over the victim's face, that he had slapped her, that happened a little bit earlier in time, and she instructed the jury appropriately, repeatedly, as to the limited purpose for which they could consider this evidence. So I suggest that this evidence was properly admitted, and I also suggest that given the overwhelming strength of this case, that this court should decline to exercise its discretion under Section 33E and reduce the charge or order a new trial. If the court has no further questions.
Thank you, Ms. Noble.
Thank you, Your Honors.
All rise.